Welcome. Frank Bruno here at your service. FrankBrunoLaw.com on Facebook or on YouTube. Who am I and why are you here? Frank Bruno, I'm in private practice. I'm in Glendale since 1997. Queens, New York. I serve Queens, the entire city, and the outer boroughs, the outer counties, right? Some Orange County, Nassau, or some. I am a graduate of Queens schools, Catholic parochial school through 8th grade, Archbishop Malloy High School, St. John's University, and New York Law School. Ventured out to Manhattan. I have a staff, too many to name, but some of the principal players here are my associate, Sebastian Kazmarek, Polish-speaking, English-speaking as well, attorney, Carla, master front desk. She's a Spanish interpreter. Josephine helps me most frequently with the estate planning work. I have Erin, who does specifically some social media and helps me with this webinar. Without her, this is not possible, although I have very good backup. Julia, in-office tech whiz, and coming in as the most recent employee is Taleli. So we are all here for your benefit. I've been in practice 27 years. I'm next door to Russo's Bakery on Myrtle Avenue, a couple of blocks from some Stammtisch German restaurant. And yes, all of my landmarks are food, so stop by. I'm active locally in the Bar Association. I'm active nationally in the American Bar Association and the statewide New York State Bar Association and the National Association of Elder Law Attorneys. And you'll see a slide. I have a slide with all of the activities that I'm involved. Today's agenda: learn estate planning, learn elder law, learn asset protection terms, just enough to make you understand, because this is a broad and deep field, right? Entire law school classes are on wills, trusts, probate, estate planning, surrogates court work. We're going to give you a summary of some of the proceedings and give you some options that may assist you in taking what you have during your life and passing it on to your loved ones, planning for potential incapacity and eventual passing away and giving away all of your assets. I'd like to direct people to this type of webinar so you can become educated and then ask questions about your specific case when we meet. So I would like to thank everyone for being here in attendance. I do appreciate it. I'm here for you, and I'll see you soon. Take a look at my YouTube channel, Law Office of Frank Bruno Jr. I have a Facebook, I have TikTok and Instagram and LinkedIn. As of right now, I put all of the videos on those social media platforms, and it's the same video across the several platforms. I may write different content for each one. I have a blog post on my website, frankbrunolaw.com. See everyone soon. Thank you. In the losing control of your belongings category, I'm going to tell you and share the fundamentals of estate planning. And estate planning comes down to three things: access, control, and timing. The acronym is ACT. What is estate planning? It's taking care of and having a plan for your stocks, your house, your bank accounts, your annuities, all of the items of real and personal property, and the timing, and when does someone benefit. So when I am alive and well, like now, before you, mentally sharp, right? Physically strong, I control my assets. If I'm disabled, someone else needs to control my assets. That could be someone through a power of attorney. It could be a court-appointed guardian. And at my death, who controls my assets? If it's in a trust, it could be the trustee. If I had used a will, it could be the executor of the will. And if I have no plan, it's going to be an administrator. Alive and well, we take that for granted. And that's why 50% of all people die without a will, because people think, I'm going to get to it. I will do it at some later point. I have time. I'll get to it. It'll be done, right? That's what we think. And hopefully you don't think that, because a state-run plan, more often than not, is not the best plan. I had someone call me today. His father had gotten remarried and does not have a will and recently passed away. And there was a home owned. And the question was, who's getting this home? Well, now the children of that deceased parent have to share with the second spouse. Probably not what the father wanted. So accident or illness, incompetence. Well, the legal word is incapacity. So if you don't have capacity to take care of yourself, to know or understand that you might be a danger to yourself or others, or that you can't do your activities of daily living. The general word on the street, so to speak, is incompetence. And you hear someone's incompetent. That's a medical word. We use the word incapacity. I often will get telephoned for prospective clients that a person that significantly of young age, if you're younger, you might not think so, but a person in their 50s that had a heart attack or a stroke. And sometimes people in that circumstance have to go to the hospital, then they need to go to rehab, then they need, right? There's an entire infrastructure of disability. And if you can't be discharged because you have no one at home and you don't have a plan in place, I have had circumstances where people will have a $42,000 bill that has to be paid because they went from hospital to rehabilitation center. They have a home, they have assets, but they just don't have the the plan in place to go home. What about Terry Schiavo? Terry Schiavo was a very famous case years ago. She did not plan when she could have. The next series of slides is on not knowing the law. Not knowing it is a threat to your family's security. Is it your plan? Is it the government's plan? What do you need to know? So let's tackle some terms. I told you what an estate is. Simply all of the assets that you own. Personal belongings, your house, other real estate, cash in the bank, in retirement accounts, IRAs, as well as any stocks or bonds, annuities or insurance policies. So there are types of ownership. I'll use a real property example, right? So a person owns a home. They either own it in their individual name, then they own it in a joint name, then they own it as tenants in common. Those are the three ways that you can own a piece of property. A single name is understandable. It's a person that has their name on the deed. What happens when they pass away? Well, their single individual name, if that's how a person owns a property at their passing, it's fixed, frozen in place, and only an estate plan or an executor or a trustee can handle that. If a person owns a property jointly, well, the survivor of the two people receives that property. It could be husband and wife. Husband passes away, wife owns it in her own name. If it's tenants in common, say brothers own a property or friends own a property, 50-50 tenants in common. You know, it's called tenants. It's still a form of ownership. And if there's two brothers, A and B, if A passes away, B owns the property alone, and then it doesn't pass through to the children of A or the spouse. It doesn't pass through to the children or spouse of A automatically. It passes pursuant to an estate plan, either a will or a trust. So in that instance, if A passed away, the heirs, Heirs, the heirs of A own 50%, and B continues to own 50%. Almost threw myself off. For bank accounts or brokerage accounts, you can own a bank or brokerage account jointly. The survivor of the two people will receive the entire amount. You can own a brokerage or bank account as a payable on death account. You can own it as an in trust for account or a transfer on death account. Often I will get a telephone call and someone will present to me a scenario. The house was in my parents' name and one parent passed away. Or a parent and sibling are on it and they want to transfer. Well, it's very important to know, was it joint tenants, joint tenancy, or tenants in common? Because that will dictate how we proceed. Can we just transfer the property through a new deed and transfer documents, or do we need to go to court, obtain letters testamentary or letters of administration, and get the permission and authority to transfer the property? It all depends on the controlling document, which is the deed. And then we have advance directives. Those are documents that we utilize during life for specific purposes. There's a power of attorney, there's a healthcare proxy, there's a living will. And I'm going to get to probate, trust, and will as separate slides. Now, you may know what a will is. It's either called a will or a last will or a last will and testament. That's what we hear on the street. These are the common terms. You may have one, but chances are you may not have one. Now, if you're at a webinar like this, you may be more interested in estate planning and you already have a will in place. However, the statistics are 50% of all people pass away without a will. A will is a legal written document that names your beneficiaries, who gets what. I love to say that, who gets what, who gets the items within your estate, and when and how. So you can give a specific request. Upon my passing, I want the sum of $10,000 to go to Salvation Army. I want the sum of $10,000 to go to Shriners Children's Hospital, right? I want $10,000 to go to my niece. I want $4,000 to go to my nephew. We never liked him anyway. or I want some money to go to the ASPCA. Now, if you have money in a bank account or a brokerage account, that can be easily handled. If you have a home, a piece of property that needs to be sold, the house or property would need to be sold first, and then the specific bequest from the proceeds of the sale would be attended to by your executor, administrator, or trustee. Now, you may think that you're protected with a simple will, but and you could be protected. The circumstances are, the fact is, when you have a will, your estate must go through probate. The will, if valid, perfectly executed, nicely crafted, a gem in all respects. It's a document that needs to be brought to court with a petition with a filing fee. So it can be great if you have a simple circumstance and you want to give maybe some bequests and divide things somewhat evenly. A will can be great. I have a different slide with some of the downsides of probate, but just factually, a will only controls what you own in your name. So I gave a prior example of owning a piece of property, jointly held, so a husband and wife, or brothers, or siblings. If you own a piece of property with someone else as a joint tenancy ownership, the survivor of the two people receives that property. So even if I put in my will, I want the property located at 123 Main Street to go to my 3 children, by operation of law, if I own the property jointly, it will go to the survivor. The will clause that says it will go to my children is ineffective. It won't be able to handle that circumstance because the property was not owned by me individually. So another item is a will, a last will and testament, even if properly executed and valid, it is only used upon death. If I make a will today and I don't pass away for 50 years, I should be so lucky. If I don't pass away for 50 years, that will can be perfectly valid for the entirety of that time, but it has no present day force and effect. It is a great document that is inactive. It can only be activated upon my death and upon filing of a petition in the surrogate's court. It doesn't control jointly held assets or even assets with beneficiary designations. So if I have a bank account and it says in trust for my 3 children, if I had any sum of money, $1 million in that bank account, and I want to give to the Shriners Children's Hospital and Long Island Jewish and the ASPCA, none of those charitable organizations would get any money, because in my example, it was in trust for my 3 children. By operation of law, at my passing, it goes to them. They just have to produce a death certificate. What is probate? Probate is a legal process by which the court identifies, appraises, and transfers ownership of state assets, and it goes to beneficiaries or whoever was designated within the will. The court will order payment for any open debts, any taxes owed. If there's a will, the court will validate the will and settle any disputes or will contests. If there's no will, the court will identify beneficiaries and it'll transfer to those beneficiaries and heirs pursuant to an administration process. Now, only the probate process can transfer title after death. So if I own a car, a vehicle in my name, the title is in my name. If I own a house in my name only and I pass away, we don't think about it, but if I'm deceased, I can't sign the title of the car. I can't sign the deed. A fiduciary, an administrator, or an executor has to be appointed to sign the back of the title, figuratively and literally, and to transfer the deed. There is a school of thought that we'd like to avoid probate, and we'd like to avoid probate for several reasons. It's expensive. It can cost you money. Probate fees vary state to state, but in New York, they total 3 to 8% of the gross value of the estate before deducting debts or mortgages. And costs, legal fee costs, right? Not legal fee costs, filing fee costs. If your estate is valued at $500,000 or more, right, we're talking about probate fees, $15,000 to $40,000. The filing fee is $1,200. Attorney fees range based on the complexity of the situation. Is there a fight? Are there heirs to be found? Are there disagreements? Is there an issue that the will may not be valid? Was it a deathbed will? Was it a Staples will? And I mean the office superstar, not Staples on the will, although that could be an issue too. So fees can add up. They can eat away at a substantial portion of your estate, which means that your heirs receive a smaller portion of the estate, right? More fees, less for family. And, the saddest part is many cases, heirs end up selling assets, selling the property. Why? To pay fees, costs, and to resolve those circumstances. A second reason to avoid probate is because probate delays the transfer of the estate to family. If a person passes away and they need to probate, it's going to be the better part of a year, maybe even 2 years. I've had instances in Queens and Brooklyn, the better part of a year, the better part of 2 years. Sometimes there's a property, a multifamily property, where there are issues in collecting rent or payment of mortgage. There are issues involving evicting people. We've had instances where a parent will pass away, one of the adult children remains in the home, and the executor is someone else, and they can't even serve or request that the person leaves because they don't have letters. They're not the executor yet. It can take many months. At the very least, it takes many months to go through probate. The national average is about 18 months. AARP, if you noodle around on their website, it shows that probate takes 1 to 2 years. While your heirs don't have control over the asset, no asset can be sold, no eviction can be done, perhaps no rent can be collected, no other assets, bank accounts can be accessed. So expenses continue to accumulate. If you have a house, you have homeowners insurance, you might have a mortgage, you might have taxes that are due. You might have water that's due. So if you have a home, you will not be able to sell until probate is complete. And that home could be sitting vacant or could be occupied with a mortgage and mortgage payments due. So what about if the property is in a state where no family members reside? This would cause additional concerns, additional problems, and additional expenses. The third reason to avoid probate is because of publicity. Just typically, most people don't keep their will on the coffee table or publish it in the newspaper. Most people keep their will in a home safe or a safe deposit box or in the sock drawer or in a cabinet, right? Because it's private. They don't want people to see it. They don't want it to be out and about and discussed amongst the family until the time for use. Yet, when your estate goes through probate, a notice must be placed in the newspaper to let the community know that your estate is in probate and your file is available in the county courthouse for anyone who wants to read. This is an invitation for creditors or disgruntled heirs to make a claim. And because probate is public, anyone can find out the size of your estate, who it's going to, when it's going to, where the people live, the names and addresses of beneficiaries, and the day they'll receive their assets. As you can imagine, people can be taken advantage of. I had a case where a surviving elderly person was telephoned by a con artist and was asked to give money. And, they depicted an entire scenario where some cash had to be given to this person for a problem associated in the estate. And they were just taken advantage of. This was a complete fabricated event and circumstance, and it really was a problem for this person. Will contests. Sometimes wills are not clear. Sometimes you leave assets to children equally, but it really doesn't say if a child predeceases the parent. Where does that money go? And that's just one example. Does it go to the sibling? Does it go to the grandchildren? What about if one child is provided for in a less meaningful way? They get less money. Well, that child may want to contest the will for this perceived grievance. They might say, hey, my mom, my dad was not in the right frame of mind when they made the will. Even if it's not accurate, they may just say it, and then you have to figure that out. And that becomes a will contest. So the fourth reason is the loss of control. So the court will be in control, not your family. The public nature of your will opens you up to a contest. And then it's very simple, really, to have a will contest. It just requires that person does not sign off on a waiver, and then there has to be a court conference. See if there's another reason. The fifth and final reason is the multi-state probate. Just spoke to someone today that the person passed away here in New York, but they have a property in New Jersey. So you need to complete your probate in New York and then get an ancillary probate in every state where there are assets. Jersey is fine. Pennsylvania has a small estate death tax. We have a lot of people from New York that own some Poconos property or own Florida property. So we see these multiple state programs. A trust can avoid multi-state probate and a will does not. So that's one of the reasons people don't want to do probate or would like to avoid it. Trust. There are several flavors of trust. As I mentioned, the prior document was a last will and testament, and we can have a testamentary trust. That's a trust provision or paragraph baked into a last will and testament, testamentary trust. Then we have the living trusts. Living is when you're alive. You make the trust while you're living. You can have a living revocable trust, living irrevocable trust. You can have these trusts, either one, in place of a will. It's a probate avoidance vehicle, and it's a will substitute. And then you can have a special needs trust. That's beyond the scope of today's webinar. That type of trust is for a disabled person that is on government benefits and try to preserve the government benefits. Now, to give you an example, some facts. New York State Bar Association has an elder law and special needs planning section. They group the elderly and the special needs person together because they both apply for similar government benefits. And it doesn't mean that the elderly person, the elder, doesn't have special needs, because they could. And it doesn't mean that the special needs person is not elderly, because eventually they may be. But those two categories of person are lumped together because the special needs trust is the type of document that services both of their needs. What is a trust? It's created when you're living. It's a legal entity that operates indefinitely. It outlives you. So we create a trust, and then we put assets into the trust. And that's what it really boils down to. And there's some circumstances here and some complications and some things to go through, but that's the general thing that we do. This is the type of common estate plan that we're going to talk about. It's a living trust. What is it? It's a separate legal entity. It is not a corporation, but that's a good way to imagine it or think about it. It's a legal entity that is set up. Can have its own EIN number. It can own things. So we create the Bruno Living Trust, and we retitle my home and put it into the Bruno Living Trust. We retitle my brokerage account and put it into the Bruno Living Trust. And then in the event that I pass away, and since I'm not a vampire, there will come a time that I do pass away, the trust itself will continue to live and take the steps that I want. I might say within my trust, upon my passing, I want the property to be sold and the assets divided in 3. I may say upon my passing, I want any individual assets I own to go to my wife. It'd be simple like that. What you do is you transfer the title or ownership of your asset to the name of the trust. And that would be for bank accounts, real estate, brokerage accounts, the ownership of life insurance policies. And in this Bruno Living Trust, I can also direct what's going to happen to my law office or any other asset, and what could happen to it and what I'd like to happen to it should I have an incapacity. So if I become incapable of handling my affairs, I might say I want the property located at 123 Main Street to be sold, or I want it to be managed by the trust. So if I'm disabled, I'd like the trust to collect rent and pay the mortgage and pay the bills and pay the expenses. I can direct that inside of the trust. Then I can have one trustee or co-trustee to manage the assets. The trustees have complete control over the management of the assets as directed within the trust. So the trustee, if permitted, can buy or sell or mortgage or do anything permissible with assets in the trust. So if they have a brokerage account and I have fantastic stock, Tesla and Microsoft and Amazon, and I want to keep it, well, the trustee can do that. If, on the other hand, these stocks or the holdings aren't doing as well, they can be actively managed by the trustee. They follow the trust's specific instructions within the trust, paying debt, distributing benefits to beneficiaries. Beneficiaries will also be named in the trust. They receive the benefit of the trust upon your death. Now, a revocable living trust, the terms can be changed at any time by the grant. So as you age, as your family circumstances change, you can change your trust to reflect those changes. You can change trustees, beneficiaries, or any instructions. A living trust avoids probate because it's recognized as a separate legal entity, separate and apart from you. When you fund or transfer your property to the name of the trust, as retitling the asset, the living trust owns the property. You don't own it. Therefore, your assets will bypass probate. But the trust has to be properly funded to avoid probate. It is critical and it is too often overlooked. We can assist you with the process of funding this. Further or more advanced planning can provide additional benefit. With proper planning, you can provide discretionary distributions. So I could say, I want to give the sum of $1,000 to my grandchild when my grandchild graduates college, when my grandchild has a religious ceremony, when my grandchild gets married. That's a discretionary milestone event. I set aside the sum of $50,000 in the event that my grandchild graduates secondary education or obtains an advanced degree, or you could earmark it to perhaps purchase a property for them. So you can accomplish other benefits unique to your situation. So if you have, these are daughter first. If you have a daughter and you don't like your son-in-law, you can provide for money for your daughter and it will never go to your son-in-law. So a few years ago, I wrote a blog article and then I did a video about that salacious title based on inquiries I was receiving. And it was, how do I make sure that my daughter-in-law does not inherit my money? And that's how you do it. You can do it by within the content of your trust. This is a protection from the grave. to protect future generations. So consider a living trust. To sum up the benefits, you'd want to consider setting up a living trust if you own a home or a property. Why? Because your heirs will receive a stepped up basis. They'll get the modified value of the home at your passing. You bought at 100,000, the property is now 1.1 million. It increased by $1,000,000. You don't want to transfer that during your life. We'd like it to pass at your own passing, pass at your passing, transfer at your passing. Your heir, your beneficiary, receive the stepped up basis. They don't pay tax on that money. They receive it at the value of that later date. You consider a trust because you want your affairs to be managed the way you direct. You'd like your affairs to be governed in the way that you'd like if you became incapacitated. You'd like your affairs to remain private. No public proceeding, no court involvement by using a trust. Sometimes I get contacted. Used to happen more frequently. I think there's a lot of education in the trust field, but I used to get more frequently a house was transferred to children during the life, sometimes to avoid a nursing home, sometimes because the parent wanted to be helpful to the child, but that adult child will now probably pay capital gains should they sell it if it was transferred for no consideration within 5 years of needing a nursing home. The nursing home may deny Medicaid coverage. I had a specific instance where 2 daughters received the property of the parent. They rented out the home, and then they did not share the proceeds that rented our home to the parent. You'd consider a trust if you're single. A single individual has special estate planning needs. You have no legal partner that'd be recognized upon your incapacity and death. You have no marital exemption for estate taxes. You need a legal document to designate a manager of your estate if you become incapacitated. Have you thought about who you'd like to manage your assets or make your healthcare decisions after you become incapacitated? Who's going to be the beneficiary of your estate? If you want to name a significant other, perhaps you're in a committed relationship, but you're not married, that person is legally a stranger to you, you need a written estate plan. Most states don't recognize or protect non-relative domestic partners. Needs to be in writing within a plan.